When the department won, the appeal was affirmed for its victory in the Noxby case. That was in this administration, early in this, between your work on the transition and your nomination. And there was a press report at that time that described how difficult a victory it was for the division, even though the Fifth Circuit had great praise for the attorney. And that press report said that the then acting chief of the voting section, Joe Rich, Kristen Clark, who we've deposed and has refused to answer questions that she should refuse, and others in the division opposed the filing of the Noxby suit in significant part because the defendants were black. Did you do anything to investigate whether that kind of culture existed in your division?
I am completely comfortable with the decision that was made by the acting Assistant Attorney General Loretta King and by Steve Rosenbaum. I am absolutely.
Again, that's not my question.
Well, but
Did
sir,
you do anything?
Actually, implicit in your question is the assertion that somehow Loretta King and/or Steve Rosenbaum, who were the decision makers in this case, acted out of some sort of animus, and I'm simply here to say categorically that they made a decision on the merits. Reasonable people can differ. People can differ vociferously, and that is not the first or the last time that will be the case here. And so I want to make sure that the record is clear that, yes,
let me reclaim my time. There is one strange fact about the Noxby victory. The career people who were in charge, which was Loretta King and Rosenbaum, did nothing to see that a press release that normally accompanies that victory was put on your website. Now, there could be other reasons. Let me ask my final question. If we uncovered strong evidence that a current supervising attorney or political appointee senior in your division made statements that this administration will never bring a voting rights case, or to this effect, will never bring a voting rights case against blacks or other minorities, I hope that you will seriously investigate, and I hope you agree that it would be highly relevant to this investigation and that we should have access to the witnesses to such a statement.
If you have a statement, bring such a statement to our attention.
I hope to uncover, bring such a statement.
Commissioner Graziano, do you yield my 5 minutes back to me?
Yes.
Okay, Commissioner Yaki.
Yes.
And Commissioner Yaki, you have 10 minutes.
I'm probably going to use a little bit, then carry it over to my next round.
Okay.
Or however long it takes for you to answer it. I'm a little bit confused by Commissioner Graziano's last remark because it seems implied that if any senior official, political, whatever, goes off on a toot, that somehow it constitutes, whatever hearsay, whatever context it is, it somehow constitutes probative evidence of something going on, and that to me is very interesting. I want to focus more really on what the department is doing. 11B is voter intimidation, but that's really a subset in some ways of the broader issue of voter disenfranchisement. What did you say?
Yes.
I am curious, and since we have you here, I'm going to use my prerogative of this time to ask you to talk about the department's other efforts with regard to voter disenfranchisement at this current time, because, again, there seems to be some sort of imputation, however implicit or explicit, that somehow you guys are falling down on the job, and despite your public statements, and I'd like to see what you have to say with regard to the greater issue of voter disenfranchisement and what the DOJ is doing right now.
Well, voter intimidation and voter disenfranchisement, there are a number of laws on the books that deal with that, and our efforts as a department to address those issues are a joint venture between the Civil Rights Division and the Criminal Division. And there are a host of laws on the books, and we have remarkable interaction with the Criminal Division so that we ensure that we are communicating and putting the full force and weight behind us. We also have, there are a number of laws that we've been very involved with recently involving ensuring the right to vote for people in the military. That's been a very important focus of Congress, and we've been working hard to investigate that. I mentioned the incident that occurred on election night 2008, where a group of people who, racists, who took issue with the fact that we had just elected an African-American president and proceeded to brutally assault the victims. That's U.S. versus Nicoletti, a case that we brought under 18 United States Code, Section 245, which addresses force or threats of force that interfere or attempt to interfere with persons' exercise of a federally protected right. We brought that case as well, and that was, I think, a very good and appropriate prosecution in that case. Obviously, we have a broad-ranging program under the motor voter law to ensure access to the ballot, and we have vigorous enforcement in that area. Section 12, by the way, of NVRA also is a intimidation provision. So, in short, there are a host of laws on the books that we work in collaboration with the criminal division on to ensure that there is fair and equal access to the ballot.
How about voter purges? What's the department doing with regard to that issue? I know that was a big issue in the 2008 election with regard to various states. Is there any ongoing?
We're actually in the process right now, and we hope to have it in the very near future. We're preparing guidance on all of the sections of motor voter because in my outreach to secretaries of state and other state election officials, I've been learning that it would be useful for us to prepare guidance so that there's understandings of Section 4, Section 6, Section 7, Section 8, which is the purging provision that you're referring to. We want to have guidance across the board so that that entities understand what the statute sets out and what the roadmap for compliance is, because there are right ways and wrong ways to enforce Section 4, to implement Section 7, to implement Section 8, and we want to make sure that everybody has the proper roadmap so that we can ensure access to the ballot and we can ensure that we prevent fraud. Sometimes there's this tendency to say that you can only do one or the other. I think we can and should and must do both.
And what is the department doing with regard to one of the problems in the 2008 election were the differing or sporadic, or how should I say, inconsistent enforcement or interpretation of voter ID laws in various states. Is the Justice Department doing anything to try and create some sort of guidance for those states that have implemented it and how they can do it without violating the law, et cetera?
Well, a number of those voter ID issues have been dealt with in connection with Section 5 submissions.
Okay.
And so we will continue to address that. There was a submission, for instance, from Arizona that was pre-cleared a couple of years ago. And so as those issues come up and as covered entities enact laws in that area, again, that is their prerogative to do so as long as it doesn't violate the retrogression provisions of Section 5 of the Voter Rights Act. So we continue to deal with that in connection primarily, but not exclusively, with our Section 5 work.
Great. Thank you. I reserve the balance of my time.
Which is 4 minutes. Commissioner Harriet.
Let's get back to default judgments and Rule 11. I take it you would agree that it's a violation of an attorney's professional responsibility to file a cause of action against the defendant without ground, right?
Correct.
Tell me what was missing from the department's evidence against Jerry Jackson